Tonight, we have more details about a drunk driving case that fell apart this week in Gander. 22-year-old Nicholas Villeneuve was charged in a crash that killed 2 people and injured 2 more. But yesterday, he was acquitted as the Crown Attorney lost key pieces of evidence. Tonight, for the first time, we can tell you what that evidence was and why it was thrown out. Here Now's Garrett Berry has our top story.
Tonight, we can tell you that the key pieces of evidence in this case were blood samples taken from Villeneuve just 2 hours after the crash, as well as an admission made by the accused that he had consumed alcohol on the night of the incident. Both of those were thrown out in this decision that was published just hours ago. The turning point was about 30 minutes of interaction between Villeneuve and an RCMP officer who responded to the crash. The officer rode with Villeneuve in an ambulance and stayed near his bedside. But the officer did not immediately tell him about his right to remain silent. That didn't happen for another 30 minutes. And even then, the officer did not tell him that 2 people had died in the crash, nor did he tell Villeneuve that he had a right to a lawyer. During those 30 minutes, the RCMP officer engaged in what the judge called directed and focused questioning. Judge Mark Linehan ruled that was unacceptable and meant, in effect, that Villeneuve was detained without hearing his rights. That's illegal. So the evidence that was collected after that detention was thrown out. Villeneuve told the officer he had consumed alcohol. He also consented to a blood test. But the judge ruled that because Villeneuve was not quickly told about his right to counsel, nor fully told about what happened that night, his charter rights were breached. The judge wrote that his consent to answer questions and give blood samples was not fully informed. He wrote, the officer's failure to put his mind to Mr. Villeneuve's rights throughout the encounter was a serious breach of his duty as a peace officer. Later adding, the public must have confidence that those who are charged with the enforcement of laws do so while keeping their minds on the rights of all citizens. It's important to note we can't know whether this evidence would have secured a conviction. There was never a trial on this evidence. But yesterday, the Crown Attorney said its exclusion was part of the reason she concluded there was no reasonable likelihood of conviction. Garrett Berry, CBC News, Gander.